you have well described the CREATES Act. I would just want to thank you and Senator Leahy for it and point out that it's my understanding that it'll save the federal government some $3.8 billion and generate an additional $250 million over 10 years. More competition from generic drug developers, it is believed, will result in lower prices for consumers. So it's a really good bill, and I am very happy to support it. On nominations, the committee will be considering 3 judicial nominees. For many of these nominees, they don't have writings. They don't have speeches. It is difficult for our staff to evaluate what kind of judge they would be. So this means we're often limited to what the ABA learns as it interviews dozens of nominees, colleagues, and what they have done in their career. One such nominee is Patrick Wyrick. He's nominated for the Western District of Oklahoma. He doesn't have a rating from the Bar Association. Those of us on this side of the aisle are concerned that the committee is moving forward with a vote despite that, which you addressed in your remarks. I mean, nominees have been rolling through this committee in my 25 years on it in an unprecedented rate, and it's hard for me to understand why we can't just wait for the ABA to do its work. It's my understanding when the ABA appoints a second evaluator, this is only done when a candidate may receive a not qualified rating. So I would hope that we could wait, and I would think that members on both sides of the aisle would want to know whether a nominee were to be determined as not qualified. I don't know if that's the ultimate conclusion, but I do think it's an important factor. Separately, I'm concerned about what little we can glean from his record. He provided the committee 3 writings and information on just 9 speeches or panels. This is not a lot of information for us to be able to discern what kind of a federal judge he would be. In one panel discussion from 2016, he declared, and I quote, "Entire administrative state is unlawful," end quote. This is a concerning statement, as the term administrative state has been used to refer to the federal government's enforcement of laws that protect health care and the environment, as well as regulations that combat fraud and abuse among large companies. Next, we looked at Mr. Wyrick's tenure as Oklahoma's Solicitor General. In that role, he consistently argued cases that advocated for a particular view that I happen to believe, and I think members on this side believe, is outside the judicial mainstream. For example, he led Oklahoma's efforts to undermine the Affordable Care Act. He argued that the Affordable Care Act did not permit the federal government to offer insurance subsidies in states that did not establish state-run health insurance exchanges. That argument was rejected by the United States Supreme Court in a case, Oklahoma versus Pruitt v. Burwell. Mr. Wyrick defended Oklahoma's bill mandating women seeking to exercise their reproductive rights to obtain an unnecessary ultrasound, a position that was also rejected by the Oklahoma Supreme Court in a case known as Pruitt v. Nova Health Systems. Now, this is a limited record, but it's all that we have to go on, and I would hope that we could wait to see what the ABA decides. I'll put the rest of my statement in the record, but I want to say one thing. When I've watched television and I've read that a child nursing with her mother was removed from the mother at the border and taken God only knows where. To me, the United States has reached a depth of immorality I never thought possible. Jeff Sessions was on this committee with me for 20 years. I can't believe that he would be part of a decision that would do this. 31 of us have written a bill. The bill's been carefully thought out. It essentially is to keep families together. It would promote family unity by prohibiting the department from separating children from their parents at the border. It does a number of other things. We have 31 co-sponsors. This, to me, in the 25 years I've been on the committee, is the most egregious government act by the United States of America that I have seen. What happens to a small child nursing with its mother? Where do they put that child? What formula do they give that child? What communication does that child have with its mother? Will that child be all right? Will that child die in custody, incarcerated as an infant? I think we ought to think about this. And for me, this is another assault weapons bill. And I do not want to ever blindside you. I tried to talk with you earlier this morning, as you know, and you have a copy of the bill. It's been introduced. I would hope, Mr. Chairman, that we could have a hearing on it while this is going on, that it could go to the floor, and we could do what Bob Dole said the Senate should do when I first brought assault weapons to the floor. And that is, this is an important issue, and it should be discussed, debated, and decided by the United States Senate. I don't know what's going to happen now that we have more than 1,000 children of any age, months old, in custody with a 1-to-8 ratio of staff, 8 children to 1 staffer, in places that we don't know about. One of them was on television last night in Texas. It was a Walmart store. I looked carefully at it. It was on MSNBC. I saw, it looked clean. There were supposed to be 4 beds. There were 5 beds. Perhaps not a big deal. But to take infants away from their nursing parent is something I never thought my country would do. I think it's time we had a floor debate, we discuss this, we vote on it, and the United States Senate will have an opportunity to express its point of view. So I hope you'll give us a hearing, Mr. Chairman, but for me, and I think for those 31 of us that have signed on to the bill so far, this is a fundamental issue on Americanism, on the Constitution, on the Bill of Rights. Everything that we stand for, how can we do this kind of thing? Thank you.